It's my great privilege and pleasure to moderate the Center for Legal Innovation and Digital Society's 17th Law and Digital Society book talk. Today we're talking about facial recognition, and I'm very pleased to be joined by the two editors of the Cambridge Handbook of Facial Recognition in the Modern State. They're going to present on this book, and we of course also have a discussant, one of my colleagues. So let me introduce you to all three of our main speakers today. We have Professor Rita Matulionyte from Macquarie University in Australia. We have Dr. Monika Zalnieriute from the Lithuanian Center for Social Sciences. And we have my very good colleague, Professor Jian Li, Executive Director of the Center for Legal Innovation and Digital Society. So the way that this is going to work is that our two guest speakers will present on the handbook, as I mentioned. Professor Li will then have time to respond and to comment, and then hopefully we'll have time for all of you to ask any questions you have of any of the speakers. And the way that we're going to do that is ideally, if you can send me your questions through the chat box, because we have, as you can see, over 300 people here, so it's a bit hard to do it by voice. But if you can send me your questions, I can kind of collate them and present them to our panelists to answer. So with that said, I'm sure we're all excited to hear what our speakers have to say, and I will turn it over to them now. So please, Monika, Rita, we look forward to your thoughts.
Okay, thank you so much, Stuart. So I'll start. Let me just share my slides. So we have some nice visuals, and you don't have to just watch my face. Okay, here we go. So thank you. Well, good afternoon, everyone. I'm saying good afternoon from Beijing here, not so far from Hong Kong. Thank you very much for this opportunity to present this book. Thank you so much from Professor Jihan Li for inviting and providing us this venue, and also for contributing to this book that we are going to present. So this, as you can see, the book that we are going to talk about is this Cambridge Handbook of Facial Recognition in the Modern State. And I'm sure that all of the audience participants are aware what facial recognition technology is, and that it has been spreading around the world for the last few years very fast and in very different ways. And both government and private sectors are being adopting these technologies. And there has been quite a lot of controversy, especially in the jurisdiction, at least where I'm working in Europe and in Australia, but I'm sure there has been discussion in China and Hong Kong as well on all the different ethical and legal challenges that these technologies have raised. But before starting talking about the book itself, I'd like briefly look at where it's coming from, why we thought of writing this book, what problems we were thinking about, and then I'll tell also what is inside the book, what you can find there. So how it all started. So essentially, we were watching the space in this, in what's happening with technology in terms of AI, and we kept hearing a lot about and kept seeing ourselves, of course, as you do, the face recognition technology appearing everywhere. So we encounter it when we have to verify our identities on our phones or at airport gates. And then there are CCTV cameras that employ this technology increasingly, and it's being used in concerts, sport venues, in public squares, for security purposes, for controlling also public protests and so on. We also kept hearing from media about how these technologies are being developed. Clearview AI, I'm not sure if you have heard of it, but it's a AI company that developed this powerful facial recognition system by scraping millions of our own photos from social media and developing this technology, which they're now using for law enforcement authorities all around the world, especially in the US, but also in many other countries. And it has been sued for violations of our privacy in a number of jurisdictions in Europe and Australia, and it was found that that violated privacy laws and was fined with millions of fines, but still actually is offering its services in some countries. So all of this kind of really made us concerned. We thought we have to do to understand a bit what's going on and do some more research on this, and what we can do in terms of regulation, governance. How can we support regulation in the space? So we collected, we formed a group of people, actually 4 lawyers. So Monika and myself, at that time, we both were working in Australia, and 2 legal researchers from Lithuania, Agne Limante and Eglė Kovaliūtė-Ragauskienė. This is the country where actually with Monika where we originate from. And so we started this, we kind of find partners with the help from Monika, London School of Economics in the UK and George Tech in the US, got some good funding from Lithuanian Research Center, and here we started our work. So we started with interviews. We interviewed around 40 representatives from law enforcement, from government institutions, from NGO sector, as well as AI experts and legal experts from Europe, and some from Australia, and also I believe also in China. A few to understand essentially the questions that we were asking is, and we wanted to understand that stage. So how does this real technology work? Because we need to understand how it works before we start talking about its regulation and how it's being used currently. Our focus was the use of face recognition technology by law enforcement. So we didn't really look much into private sector use, so more like government use. And then what ethical and legal challenges this technology raises from perspective of different stakeholders, and what are the current already existing regulations, and also what are the future upcoming regulations in this of these technologies in different jurisdictions. Our special focus was Europe and Australia. Now, so what we found very briefly is, well, interestingly, while let's say facial recognition technology, we all know, has been extensively used in China, in Europe we found government authorities are not using it that much, or at least at the time when we were doing interviews and researching kind of 3-4 years ago, they were not that widespread at all. UK was the most active in experimenting with facial recognition technologies in Europe, and it trialed it in live sports events, music concerts, and some public squares. And actually, UK also was the first jurisdiction where the first case on facial recognition, the Bridges case, was decided. I'll probably briefly mention that later on. Now, in comparison, like Germany actually is much more conservative state and much more kind of privacy protective. And there was almost very few even trials going on. Like, for instance, police in Hamburg has trialed some facial recognition technology in Berlin, but they with the help of volunteers. So really just trying to see whether it's accurate, and they didn't like the results. And there was some discussion whether they need to introduce laws, because I think the clear issue was there's a lack of legislation, but this was abandoned, and essentially Germany was waiting until the EU AI Act was adopted, and it has been adopted recently now. And then in comparison, Australia, going to another part of the world, also to our kind of surprise, we found that facial recognition technology was not that yet widely used by police. Well, at least to the extent we know. So we know that federal Australian police have trialed this notorious Clearview AI, and they were found that their trials were in breach of privacy laws, by the way, because they didn't even think that they have to conduct, for instance, privacy impact assessment when trialing it. We also have heard the New South Wales police, which is the biggest state in Australia, they implicitly, sometimes explicitly, kind of did not deny that they're using facial recognition technology, but the biggest problem, there is no transparency. So we don't really know to which extent, in which cases, for what purpose it's being used, and transparency, as we'll talk, is one of the biggest problems. So when we of course asked also about opportunities of this technology, and law enforcement officers, and also AI developers, who of course are very passionate about this technology that they're developing. They pointed out efficiency and cost saving in, let's say, ensuring public safety. Well, I think can imagine quite easily that, let's say, if the police officer gets a photo of a suspect, and they have to then watch hours and hundreds of hours of CCTV footage to try to see whether that person is appearing in the footage, it's much less time and cost efficient than having it done by AI technology, which can identify that suspect in the CCTV footage by using facial, recognition technology in just a few minutes, probably. But on the other hand, there are a number of ethical, legal risks and challenges have been identified, and we focus onto 4 of them. So, of course, privacy. We all know that facial recognition technology is a great threat to privacy. Our face prints are being taken, recorded, saved, and depending, then it can be used either just for that particular identification or identity verification scenario. Or actually, it can be saved and used possibly, later on for all different purposes. And that might create the, very large-scale public surveillance, which not necessarily only serves public safety, but also might be some other, government purposes. A second problem is accuracy. So while identity verification technologies like the ones that, let's say, airports use are said now to be very, very accurate. Identification technologies where, let's say, our picture is taken and then the system tries to match them against thousands or millions of pictures in the database are still sometimes not high enough, and there are of course errors. There will be always some errors, and the bigger problems is related to with kind of the related problem is bias or discrimination. Is that these technologies are even less accurate on already disadvantaged groups like people of color or people of certain ethnic groups whose images, maybe there were not enough images fed into the training data sets on which these algorithms were trained. So then there is a risk that the use of these technologies will lead to even further discrimination of these already disadvantaged communities or groups of people. Now, another problem is, of course, how these technologies might be used. So, apart from ensuring safety, they also might be used, for instance, to limit legitimate protests and constrain freedom of speech. And maybe Monika will talk about that because that was her topic in our project. And the final probably challenge that we looked into is a lack of transparency. And that's, of course, when we don't have transparency, when we don't know whether police is using this technology, for what purpose, where, and how they're using it. We can't really talk about whether the use is reasonable, or whether, so to say, the different interests are properly balanced, like interest to ensure public safety and our privacy rights. So transparency is sort of a underlying sort of a requirement before kind of we can talk and understand whether we are really having issues with this technology or not. But at the same time, of course, police authorities very easily shield behind their public security shield, saying, well, we can't disclose so much about the use of technologies because it will undermine the entire purpose. The suspect or like criminals, if they know that cameras are hanging out there, which can identify them, they simply will circumvent them. So this is, another challenge on which I personally was focusing in this project. But even while conducting these interviews, and we of course understood that our research, just a group of us researching that's not enough. We really need more interdisciplinary and international discussion on these technologies. And that's where the idea for this book came. So what is the book about? So essentially, I think it's even if I'm, I'm an editor of the book, I think it's a great book. So I really recommend reading it because it is, first of all, it actually offers you an interdisciplinary approach to these technologies. So it is like mostly the main discipline, of course, legal and regulatory approaches to how current laws apply and how laws should be revised in light of these technologies. But we also have very important sociological and technical chapters from experts of social science researchers and also technical experts explaining how these technologies work, which I believe are unnecessary before we enter into legal discussion. Also, this book presents international perspectives from all 5 world regions. We have book chapters discussing Europe, North America, South America, Asia Pacific, and Africa, which I think that's I'm quite sure that's the first book of this kind where we can hear from scholars all around the world how their regions, their jurisdictions are dealing with the challenges posed by these technologies. So overall, we have 34 contributors from 12 jurisdictions around the world, which is I think amazing. And sort of this breadth of expertise really helps us look into different aspects, different angles into this topic. And our special focus are, as we identified already above, was privacy, bias and discrimination, transparency, and freedom of speech. But you hear, of course, a lot of other legal issues being identified throughout the book. Now, I'll just quickly kind of explain kind of what chapters we have and kind of how the book is structured, and then I'll hand over to Monika very soon. So the book has 2 parts, and so the first part is discuss about it's in particular, well, actually kind of sets a background discussion with some technical and sociological chapters and identifies and discusses some main legal challenges. So the first chapter, led by Professor Neil Selwyn here from Australia, actually, and also, and then contributed to by very highly established professors here in Australia in social sciences, talks about exactly social perspectives to facial recognition technology. It's an excellent chapter discussing essentially how our technologies are affecting now our lives and will affect in the future, and how will change our lives, from like social science perspective. It's, I think, very refreshing for a lawyer to read this sort of kind of different aspect, kind of different way how people looking into that. Now, the chapter 2 is written by Dr. Ali Akbari, and he's an actually AI expert, not academic. At that time when he was writing, he was working for KPMG consulting, but he's been kind of expert in machine vision for many decades, and he introduces us how actually these technologies are developed and how they function in a very clear way. I worked with him and kind of made sure, I said, please let's write so clear that all lawyers can understand. So I think before we read technical chapters, we really need to, before we kind of read and delve into legal chapters, it gives a really good introduction of, on different types of technologies and how they developed. And then it helps us to understand, at which stage we can regulate and who can be, subject to regulation. Very important chapter. And while Simon Taylor is also looking at it from technological perspective, he has technical background, but actually he's looking at it from more historical, how these technologies have developed over time, which gives us a broader view. And then the following chapters in this part looks into selected problems. So let's see, my chapter talks, as I said, about transparency or lack of transparency around these technologies, and I chose to focus here on one particular actually reason for lack of transparency, that is trade secrets. So, of course, these facial recognition technologies are developed by private companies, and they protect their algorithms and all information around its development and testing by trade secrets. And I kind of query to which extent, trade secrets even further inhibit this transparency around technologies, especially when individuals want to get, for instance, some clarification, about how these technologies function. Now, further chapters discuss privacy issues. Of course, privacy is the main legal issue that is related to facial recognition technology. And Jake Goldenfein from Melbourne University discusses these challenges. Then Marcus Smith and Monique Mann discuss bias and discrimination. So apart from lack of accuracy of technologies with relation to already minority groups or minority races, they actually also highlight a social discrimination aspect, which is also very interesting. The argument is that even if these technologies become so completely, so to say, accurate with relation to all groups, and technology itself is equally accurate to all groups of all races and ethnical backgrounds. The other problem that law enforcement authorities might use them in a discriminatory manner. They might use them against groups that are already disadvantaged, and more than, let's say, against groups that are less advantaged. And that's social discrimination. I think very interesting aspect to keep in mind, that it's not only about how technology is developed, but it's very important to ensure that it's used in a non-discriminatory manner. And then Monika, who I'm sure will probably talk more about her own chapter, but it talks about use of these technologies in public surveillance space, in public protests, while our last chapter in this part is produced by Agne Limonte from Lithuanian Social Science Center, and actually she looks at it into an kind of a very interesting, from an interesting perspective, how these technologies has been used in war situations, and in particular in the currently ongoing Russia's and Ukraine military conflict. Of course, this information about kind of exact use, extent of use is difficult to get, but there is media articles, and she looks into that to try to determine whether whether to which extent it helps different parties in war, and what are the problems with the use of this technology in this context. And now part two now actually moves from sort of issue-based kind of structure into looking into different jurisdictions. So if you are interested in looking how facial recognition technologies have been used in different areas around the world, and how they've been regulated, or what initiatives are being proposed, here's the part for you to look into. So we have overall 10 chapters. So here you can see we start with Europe, looking into European law. So chapters by Simone Kuhlmann and Paul De Hert and Georges Bochiar from first Germany and Belgium. They are looking into how these technologies fit under current European laws and human rights framework in Europe. While Nora Lloydian and Julia Gentile, they examined it from UK perspective, and certainly they are looking into the Bridges case, which actually, as I mentioned, it's the first case on facial recognition technology, and it was a really an important case where one of the civil society kind of leaders, Bridges, they sued the police for trialing that technology in UK kind of public squares, and the police was found in violation both of privacy laws and discrimination laws in the United Kingdom. While it was interesting to see that police really kind of did their best, it looked like, to comply with those laws. They did a privacy impact assessment, but the court still found that privacy impact assessment was not appropriately conducted. There was not sufficient legal basis clearly regulating when and how technologies will be kind of trialed or applied. And they also find that it violated this particular trial, it violated discrimination laws. While there was no evidence that technologies discriminated technologies, but the police apparently did not conduct any investigation whether these technologies are non-discriminatory. So they should have taken proactive steps in kind of examining beforehand whether there are any discrimination issues. So this case is discussed by Nora Lloyd, and I think and Julia Gentile also mentions it and looks broader into kind of regulation of these technologies in the UK. And then we have another two European jurisdictions, Germany and Lithuania, as two case studies where also we're looking into kind of national laws, also how they're addressing it. I think having Lithuania here is very important. We don't find Eastern European countries very often in these sort of, international volumes. And Eglė Kavaliūnaitė-Ragauskienė, our colleague at Lithuanian Social Science Center, she kind of nicely points to the problem that one thing is to have certain laws, but another thing is also how these laws are respected or completely ignored by local authorities. So she kind of adopts this sort of legal realistic approach to say like, well, even if we have perfect laws, sometimes they don't work. So maybe that is relevant for some of you listening to this. Now, and then we hear the last 5 chapters look into all the other continents around the world. So we have a chapter by Malin Findlay and Justin Hurwitz about face recognition technology legal developments in the United States. And you might know that US was one of the first jurisdictions or like different states in US that banned use of face recognition technology some years ago, but then these bans were removed and different regulatory initiatives were proposed and kind of approaches were adopted or still being discussed in the United States without one single, kind of federal wide law yet. But a very, I think, important development because that's the United States is one of course, the leaders in developing that technology. So regulating its adoption is really important to see, what they're doing there. And then we have chapters discussing about laws regulating these technologies in Brazil, in China by Professor Li Hanji and Peng Zhou. Maybe, hopefully, Professor Li can also tell us a bit more from like what are his own ideas. What I was very interesting to read about, especially recent cases in China were limiting use by private sector more, but still very relevant. And Nessa Lynch and Liz Campbell reviews the current situation in Australia and New Zealand. And finally, we have a team of scholars presenting their study on this use and regulation of technology in Morocco. And I think this chapter, I was very interested in reading it because it shows how these technologies are used in authoritarian government context, and also in jurisdiction where there is very little awareness of these technologies, and that's why quite little awareness of the problems around these technologies, and that's why sort of I think which makes it sort of easier for the government to adopt it because nobody talks about it much. And here's my last slide. So just to reiterate, the book was published this year, and the great news is that it's open access. So you can go to Cambridge University website just by googling the book. You'll get into that website. You can download either the entire book, or you can also download each individual chapter. If you like, so please do download, read, use a site, and discuss. And that because that's our entire idea is to encourage international discussion and exchange of ideas on this topic. We are thrilled to see that it has been already cited in United Nations Special Rapporteur on the Right of Development report, a recent report where this the face recognition technology was kind of one of the examples that we used to sort of also demonstrate that the technologies can have very different impact in different countries and in terms of also development. Well, that's it from my side. I will now hand over to Monika, and of course, I'll be happy to answer any questions later on.
Good afternoon, everyone. My name is Monika Zalnieriute. I am one of the senior principal researchers at the Lithuanian Center for Social Sciences. And good morning, perhaps from Lithuania, where it's still pretty early. It's very nice to join people so far away. And thank you so much for having me here, Jianli. I know that the biggest thanks is to you for organizing this and for inviting me and Rita here. Rita has done a wonderful job of introducing the book. We decided to split the job that Rita overviews the book and sort of tries to present the core work that has been done and the background to the book. And I will perhaps try to share a little bit about sort of conceptual aspects, how I approach it, and what we also thought to perhaps do with the book. So I will just discuss a little bit the power of these technologies and protest aspects, as Rita already mentioned, what kind of public surveillance issues are there, and try to combine it with my own work on procedural fetishism. So each time that I mention procedural fetishism, people think like, what exactly that is? Is it Kafka's trial, or you know, what kind of thing am I talking about in the context of institutional power and technology? So in fact, it's a simple thing. It's an overemphasis on procedures and safeguards. And I will try to explain why I think it's very important to talk about it in the context of facial recognition technologies. And also, it's an assumption that due process and transparency can temper institutional power. So let me explain very briefly what I mean by that, also in the context of facial recognition technologies. So, of course, procedures are very valuable, and I will discuss that in the context of the case that Rita has mentioned, the Bridges case. What kind of procedural safeguards were there in place and what were not. So they do play a valuable role. That's not to debate that. But procedures alone can be dangerous, for they can legitimize excessive power. I will argue, especially in the context of political protest, that was the focus of my own work. And also they can obfuscate the substantive problems that we face today in the context of technology and technological infrastructure. And I will also discuss what I have in mind. But just to briefly mention is that by focusing on safeguards only, we miss big points, important substantive issues such as climate change degradation, soil degradation, labor exploitation that is involved in the development of these technologies, and various AI tools, including facial recognition technologies. So we can discuss the minor issues of whether the impact assessment was done here or there, but then we always are unable to see the bigger picture, such as, for example, that the continuous development and the sort of global competition and development of these technologies leave our Earth more and more degraded and the soil exploited all around the world. So it's impossible to actually discuss these issues if we only adopt the procedural lens. That's my claim. Okay, what has happened here? So I will not go into detail because when I talk about facial recognition technologies, I talk about power. So what is institutional power? And it's, of course, the government. It's, of course, the state. It's, of course, the police. It's also, so what happened? Oh, but it's, of course, also private power. So this, I think, looks lovely. It's the private power, and Rita already has mentioned and shared a little bit about clear view AI technologies and various other things. And of course, we use facial recognition technologies in various contexts in private use, such as, you know, just opening our iPhone sometimes, or doing various other things with private domestic tech tools. So facial recognition technology is actually quite widespread. Okay, so what is technology in this discussion and why it matters to discuss the power balances? Actually, this was the main driving force for the handbook that me and Rita, we thought, okay, so what angle do we adopt? How do we discuss facial recognition technologies? And we thought, maybe the shifting power balance between the state and the citizens. And of course, like I mentioned, private actors are really important here too. but it's slightly distinguishable in a sense that we can't cover everything in a handbook of this length. We will think about another one, of course, but it's a bit different in a sense that the state and state institutions do own the monopoly of force, so they can actually use these technologies to various purposes that are actually having very significant consequences on people and citizens and various communities within the states and outside the states as well, that we discuss. So we thought that discussing private context really matters, but it's slightly different. And of course, private companies do cooperate and produce this technology for the governments in various countries, as Rita already discussed. So our focus in the book, of course, is facial recognition technology. And let me briefly go through what it is, but not in a sort of traditional sense explaining how it works, because like Rita mentioned, many of us do know that, but why I think it matters to keep the facial recognition technology in the big picture. So here we can see the sort of CCTV camera that we supposedly here is connected with the automated, AI technology here in the corner. And I want to start by sharing a nice piece of artwork called The Surveillance City here, the rise of surveillance cities today here. So that's a piece of artwork. It's conceptualized. And if I open the next slide, perhaps in the reality, it looks more like this, but of course, art gives us a sense to see it slightly different. So facial recognition technologies, like Rita already mentioned, used in many, many different contexts, but mainly in law enforcement, of course, but also in banking, also in collecting taxes, also in distribution of social welfare. This is supposedly social housing provision. Facial recognition technology is used today even for such very purposes that we didn't have a clue that it might be useful in those areas. Of course, policing, like Rita already discussed, airports and so on. So I will not go into detail what it is, just perhaps our colleagues in the book that written technical chapters, Ali Akbari and Simon Taylor, I think discussed it very nicely, how this technology was developed, what it is, how it measures the different parts of the facial features to sort of then provide a match in the system for the law enforcement or other institutions using the technology, how it manages to make those comparisons. An interesting fact, by the way, talking about institutional power and facial recognition technologies, and maybe a lot of members of the audience here might know better which city in China this is, because it's a very interesting fact. So apparently the Chinese authorities were very proud and sharing this information that the facial recognition network in this particular city can identify an individual with over 3 million people within 7 minutes. So at least it took that long to identify a BBC reporter in that city. So I'll be waiting to hear, maybe the members of the audience or our panelists do know what city exactly that was. Perhaps a very tiny city, because I think in 3 million in China is perhaps a small city, whereas it's all Lithuania. So just for comparison. So it sounds huge, it sounds huge to us. 7 minutes to identify a person sounds very, very powerful. And apparently it shifts that balance of power, because if we had traditional methods of policing, even with the CCTV cameras, you still need a lot of, like Rita said, you still need a lot of manual work to actually, look and find and identify and find the match and so on. So the power, the efficiency level of automated AI is, incomprehensible if we look at this example. Okay, so what is the problem? Like we already discussed a little bit, and the driving force perhaps for our handbook and the collection, this international collection of various scholars from around the world, was the question how the facial recognition technology increased this institutional power. And it does so because the facial information can be collected from a distance without our knowledge. Yeah, we might not even be aware about this. So apparently the balance shifts very strongly to the side of the state and the institutions of the state. So no need for significant resources, like I just mentioned, and Rita discussed in quite a bit. So, and an interesting point that I am particularly interested in, it can impact significantly on political protest and freedom of association, not just freedom of speech, but in particular freedom of association. And I think that particularly is important in the context of Hong Kong pro-democracy protests, which I will try to cover in a second, and I hope to hear more from the audience. So there is no regulatory framework in most of the jurisdictions that we covered in our handbook, and also I think that's the general vibe. And the first judicial ruling, like Rita mentioned, is in Bridges versus South Wales Police in the UK. There's several more decisions coming from the French courts, and also European Court of Human Rights has briefly touched upon the use of facial recognition in a relatively recent case, Glukin versus Russia, although it was not a main issue there. But nonetheless, international tribunals, at least in the area of human rights, are also discussing the case. So my starting point, and I think also for the handbook that me and Rita, when we started exploring this, was okay, so privacy is impacted, but many more issues are impacted. Like Rita already mentioned, transparency is also just the beginning with privacy, but also many other substantive issues and human rights are impacted by the use of this technology. So here we go. This is the post lamps in Hong Kong that the protesters were pretty sure that the police were using facial recognition technologies, although the authorities apparently denied that, but the protesters were nonetheless unconvinced. So I think many of these lamps in the city were smashed to be sure that their faces are not being collected and stored in a database and later could be used for various different purposes. Also here, I think, is the use of the laser, simple lasers that I think in the 90s we could buy, in various places just for fun and play around. Perhaps this is the stronger version, but also this apparently interferes with the work of CCTV cameras using facial recognition technologies. I think this also comes from Hong Kong, this picture. But it would be great to hear more from our colleagues there. Of course, like Rita mentioned, facial recognition impacts equal protection and non-discrimination. Traditionally, people call it biased, but I would like to be slightly stronger on this and remind of the sort of very strong colonial and racist roots in the development of this technology, which I think is very strongly related to its deployment and use today. And what I have in mind is, the sort of pseudosciences now that they no longer regard it as such, called phrenology, and sort of criminogenic identification of criminogenic faces. Here we go. The sort of technical infrastructure and the development of facial recognition technologies are actually building on the sort of groundwork laid by these no longer scientific areas. And there was this famous Lord of the UK, Lord Dawson, I think, who was one of the first people to argue that we can identify criminal features in people's faces, and this kind of uptake was very sort of prominent in a lot of different colonial territories, not theories. And I think a lot of the groundwork for this kind of work was also developed in India. Like Simon Taylor in our chapter discussing historical roots and development discusses very nicely, facial recognition technology is not really developed only in the United States, and not even majorly in the United States. A lot of different countries, including actually Lithuanian's own neurotechnologies company, a very famous company who by the way, which collaborates with India's government in producing the Aadhaar, one of the largest, perhaps the largest digital identity system in the world. So there is a lot of different cultural aspects and sort of technological strength involved in the development of these technologies that are not really focusing only or, sort of focused and clustered in the US as is typically thought. So thanks to our colleagues discussing that thoroughly in the handbook. So why it matters, like Rita already briefly touched, the context matters, how the technologies are deployed, because, okay, fine, we might have a technology that does a perfect match. Yeah, it identifies the person. But in certain contexts, and perhaps in the majority of contexts, but particularly in certain countries such as the US, for example, where we have so many problems with the over-policing of certain communities that are racialized, we have a lot of problems because the system has so much data on these communities that then later we have a lot of these false positives and the so-called over-identification of people that is actually false. And there are repercussions. I'm sharing this beautiful picture of Jean-Michel Basquiat, a good friend of Andy Warhol, a good colleague who drew this picture who painted this picture in the memory of his friend killed by the police. So just to illustrate the problems that are there with the policing in the US, it's a long-term problem. It's not just now that we have George Floyd and other people that have been killed by the police in the US recently. So what does the law say all about this? All about these issues that me and Rita were just discussing here and we cover in the handbook. What kind of laws do we have? So we have 2 separate chapters discussing this particular case, why we believe it's so important to discuss, because it's the very first case on facial recognition technology. And it's great that it ruled that mass indiscriminate use of facial recognition technology by the South Wales Police in the UK was unlawful. However, I see a problem here because it was unlawful merely for a technicality, so-called. Unlawful because it was not in accordance with the law. Okay, so this is great. This is the first step of the human rights famously known as three-step test. So it should for any measure interfering with the human rights, if the measure satisfies the 3 steps in this test, then apparently there is a breach of the European Convention of Human Rights. So because the UK was discussing this matter under the European Convention of Human Rights, they adopted this test. And if the first limb of the test, which is any interference with human rights, in this case with, I think, right to privacy, was not in accordance with the law, then apparently we have a problem and we have a breach of the UK Act implementing the European Convention of Human Rights. So, okay, great that we have a finding that the use of facial recognition technology for mass surveillance purposes, indiscriminate use of such. It's very important to highlight that it was used in the city square, in the city streets, just for random sort of indiscriminate purpose. So the judges found that it was unlawful, but in general, they said, if the police had procedures in place, such mass surveillance would be okay. I discuss also this case in several pieces that I published, not in the handbook, and I discussed that this is actually quite problematic. And now I want to say that this kind of approach, which I call procedural fetishism, is very problematic, because what it does is that it diverts our attention to the existence of procedures, like I already said before, without leaving the space for us to discuss the broader issues, whether, for example, we believe that having mass surveillance of our streets and city squares is okay in the first place. Yeah, if it's proportional, if it's necessary in a democratic society, these kind of questions, which are the second and third limb of the human rights 3-step test, sort of gets lost. And when I talk about procedural fetishism, I want to draw your attention to, you see a lot of beautiful buzzwords there. So we have words such as audit, human in the loop, responsible AI, impact assessment, ethic principles, and so on and so on and so on. In my own work, currently I try to explore how this kind of vocabulary infiltrates the legal discourse, because actually we're not ethicists. We don't really discuss ethics. We didn't study philosophy or traditions of ethics, but all of a sudden it's all about ethics. And of course, none of the people in the room are, typically are ethicists. There might be people who are politicians, there might be people who are lawyers, but we all discuss ethics and we have no idea what that is. So procedural fetishism, in my own work, I argue that it's intentional. It's a strategy that is used, first of all, by corporate actors. And when I use this slide, I want to show that it's the language that is suitable for corporations to promote their own interests in the discussion, to perhaps avoid regulation and sort of promote self-regulatory frameworks by arguing that, by having an ethics board, for example, we know certain organizations do have not only ethics boards, but also oversight boards of sort of establishing a tradition of regulating themselves and setting an example of what kind of regulator in this field should be, also as a strategy, I think, to avoid regulation. But so procedural fetishism of this kind, focusing on procedures alone, distracts us from the questions about the concentration of power. That I was trying to discuss a little bit in this presentation, and I think was a very important aspect in writing this handbook. So small issues over large issues. So the problem here, like I was trying to explain a little bit, is that safeguards and procedures cannot substantively limit the power. It can certainly establish certain rules, but then the discussion gets really narrow. And that's the problem, I think, because then we sort of get lost, like this person in the room with many, many mirrors, that the picture is sort of distracted. And here in the second piece of artwork, which is the surveillance city, we can't see the surveillance anymore. It's just a beautiful colors, beautiful piece of artwork. And all we ask is that the powerful state institutions such as police simply have certain procedures, but we no longer ask if we wanted to have the facial recognition all over in our cities and squares and schools, school canteens, and so on in the first place. So here, the facial recognition camera is gone, and my sort of aim, at least driving my own work, but also one of the important features of this handbook is to ask that we bring the facial recognition camera back in the picture, and we discuss how, in fact, we could regulate that thoroughly, not just within the terms set by the powerful institutions in the first place. So what should we do? What should we do? There are many, many things that we can do. I'm not sure that we can discuss them all now, because I think me and Rita really took generous time to to present our ideas. So I might be just running very quickly through these. There are many different things that I think I'll leave to discuss in the future and perhaps in the second handbook. But of course, greater political scrutiny, novel, ambitious laws, fortified enforcement, redistribute power and wealth of the companies developing these technologies. Perhaps what I mean here perhaps is splitting Googles and Facebooks and so on, and democratize the tech infrastructure and companies. And this goes beyond the so-called inclusion of equity and diversity sort of discourse. This goes a bit further to perhaps thinking about the public utilities approach to these technologies. If we're talking about the development of, for example, public surveillance technologies, then my argument would be, why don't we look at the ways to perhaps also own them publicly, not just privately, where, like Rita mentioned, we have so many problems with secrecy and lack of transparency, and also intellectual property regimes, trade secrets, and so on, where it's impossible for us to know how the technology works and so on. So also important aspects that I couldn't cover extensively here is, decolonization of tech infrastructure, still a lot of resources coming, for example, not exclusively, but extensively from certain parts of the world, and then the benefits in other parts of the world. And I think that important aspect is, especially for scholars like us who have worked so long in Australia, we should listen to indigenous epistemologies trying to rethink the ways how we approach these technologies, what are they doing, and how they treat different groups of communities in the world. So I wanted to share an interesting book, not just our book, about the new colonialism of big tech called Data Grab. You can find this book online. So procedural fetishism and sort of increasing technologization of the public space, which facial recognition technology is, of course, a very important tool in, fighting that is an effort on many fronts. And in this handbook, we try to touch on some of them, how this technology can be regulated in different jurisdictions, and how different conceptual approaches intersect with the use of this technology in different areas, like Rita discussed in part 1 of the handbook. So, of course, for those who are interested in my work, I will briefly share. I have a very extensive article discussing procedural fetishism. So you can find that in Indiana Journal of Global Legal Studies. And another book that I recently published with another colleague called Money, Power, and AI briefly touches upon that. But we want to go back to this slide and promote the handbook, which discusses facial recognition technology. And like Rita mentioned, importantly, it's an open access book. We paid a lot of money for that to be open access. So we hope you will use this, chance to download the full PDF and use it for your as you wish. You can even upload it where you like. There are no restrictions of what can be done with it. So we are very happy that we managed to secure the funding. And we hope that you will enjoy the book. So I think I'll stop here, and I will give the floor to our moderator, and I'm open to questions together with Rita. Thank you so much for giving us this opportunity to introduce the book and the main problems and approaches we discuss in this handbook. Thank you so much.
Thank you very much, Monika and Rita. It's an excellent piece of work, and I think we can all benefit from the efforts you've put in. I did put a link in the chat box to the book, so people can download it right now. It's right there, easy to access. But right now we're going to turn it over to, as I said, to my colleague, Professor Jian Li, Executive Director of CLINDS, and he's going to be our discussant. And once he finishes, then again, we will have time for some Q&A from the audience. And again, please, if you do have questions, submit them to me in the chat box, and I'll present them to the editors at the end. Okay, so over to you, Jian.
Thank you, Stuart. And thank you, Rita and Monika, for the great sharing and a wonderful book. So especially thanks to Monika, who wake up at 5 a.m. there. And I guess a lot of audience was thinking about the same thing, which is that, so how could you get like so many interesting artwork on your slides? So that might probably have nothing to do with the substance. So both are very good. And I'm very impressed with all this kind of like beautiful art. And I guess, are you yourself also an artist? Because that was really impressive. All right, so I have a number of questions, but I would be happy to probably reserve some time for our audience. I think it's great to have this open access book. So Monika said that you spent a lot of money on that, but I would still highly encourage our audience to get this one, the physical one, because it's actually great to have the physical one at hand, so you can always check whatever that you need. So the book covers a number of different jurisdictions around the world. So as Rita just mentioned, so I'm actually just curious. So after like studying all these regulations about facial recognition technology, do you see any pattern across different jurisdictions? Do you see any similarity or differences across all these countries? Because I guess so probably they have very different power dynamics, or if we use the words by Monika, they have very different procedural fetishism. So, and if I ask you to identify the major types of approach, probably based on different social, political, economic situations. How would you explain that to our audience?
Monika, you are smiling nicely. Are you ready to talk? You want to go first?
Yeah, I can try that. I think my unmuting function worked. Thank you, Jianli. Well, first of all, for also promoting the hard copy. This is great. And for your very nice words. And for having us here. So and what a great question, similarities or differences. It's a very interesting question. And I think you perhaps, especially having in mind sort of the difference between the so-called liberal democracies and more authoritarian regimes, my own perspective, and Rita might have a completely different opinion, is that despite of these massive differences in legal cultures and constitutional regimes, the use of the technology, because it's typically outside of the legal framework, we don't really have the particular rules in place. We have certain rules, and the regimes might be emerging in certain parts of the world, and through the generic legislation, let's take Europe. We had GDPR already for a long time. We now will have the EU AI Act. Sorry for mentioning my previous institution, EUI. So we do have certain rules emerging that might be potentially relevant for the regulation of facial recognition technologies. But however, the regulatory framework is only sort of starting to emerge, if at all. In certain places, we have bans on the use of facial recognition technologies in a very limited circumstances. We're not talking generic bans or anything like that. We're talking about maybe limits on the use of indiscriminate mass surveillance in the city square, for example. So we do have certain sort of small differences, but I think generally the deployment, the use, which is outside of sort of major substantive laws, I think is very similar, actually. And Rita might have a different opinion because she was really doing a lot of hard work with the interviews, and the interviewees might share different perspectives on this. But my observation, at least sort of grounded in studying this issue for a long time, is that at least in the law enforcement context, the so-called liberal democracies really employ this technology very similarly to other regimes across the world that would be described perhaps not so democratic, or not so, not a traditional liberal democracy. And of course, China, India is there. Well, India is a biggest democracy in the world, but nonetheless. So the use of the technology for various purposes, also to target certain populations, is in a way similar, at least in my opinion. In certain cases, it's very easy for the researchers in the Western in the Western cultural field to recognize and to see that the technology is being deployed, let's say, draconically in for example, against the Uyghur communities, or in Jammu and Kashmir in India, and so on. But much more difficult to talk about it in a similar way when this technology is used, for example, let's say, in the context of indigenous and Aboriginal people in Australia, or people of color in the United States. So it's I would say the patterns of use are quite similar, slightly different, but not as different as we would have imagined, at least in my own work. And now Rita might contradict me if she has a counterpoint. Rita, go ahead.
Well, yeah, I think, Jihan was asking also about like emerging regulation, if there are common patterns. I think, Monika commented more about like how it's being used. Maybe I'll just make a comment in terms of regulation as well. I think my feeling is kind of in all countries, if there is a discussion around that, is about kind of how we balance those interests of ensuring public security in a broadest possible way, and then the rest, privacy, and other rights. And I think it depends, of course, on laws and on culture, how the balance is reached in different jurisdictions. So even if we look inside Europe, I think some countries have much stronger privacy culture than others, and that they weigh that balance also, like in Germany, for instance, they are much more careful and much more strict in regulating the use of these technologies than in UK, where I think they engage with procedural fetishism, as Monika said, where they just said, let's just have some procedures around it, and police is fine to use it. We don't mind, because UK is known for many cameras, for in European standards. And let's say in Germany is they are much more careful with technologies, and they have much more kind of tip the balance on the other way. Only when it's really really necessary and address some specific needs, that's when we allow police to use it. And I think now, as UK is not a part of EU already, I think the rest of the Europe also demonstrates a similar stance when in the recent EU AI Act, they established, as far as law enforcement is concerned, that law enforcement cannot use live recognition, face recognition technologies as a general rule, but only in 3 exceptional scenarios. And there are three detailed rules when essentially, let's say one example is when police is seeking to identify or locate a particular specific criminal, suspected of a certain level of crime, then they can switch on that face recognition technology in CCTV cameras and try to find that criminal. But overall, general surveillance for a kind of general purposes, let's say, is not allowed in Europe. I think if we look now if we look this more liberal countries and not so liberal, let's say more authoritarian countries, my feeling was that governments that apply less democratic measures, they also feel they need more tools to keep security, and they leverage on these technologies. They say, well, for the purpose of security, we have, we can use these technologies as much as we need. And they give much more weight to the security, public that security, and much less weight to that, to all the, human rights. So then this balance is tipped. So I think these are sort of commonalities and differences, maybe that Jihan Lee was referring to, and maybe, that's it. Maybe Monika will agree with me, but again, it's such a subjective way how we look into that variety, a puzzle of many, many different legislations trying to fit into bigger picture and how they all relate. That's something to think about.
Right. Thank you, Rita. Thank you, Monika. I don't think there's a big disagreement between you both. So my second question, so probably that's the last question that I have, is about regulatory design. So Stuart might know this much more than I do. So we all know this kind of facial feature is kind of a personal data, subject to a lot of privacy protection. And Rita mentioned in the beginning that Germany had a bill, so which didn't pass successfully, to specifically address FRT issues. So my question is that, so from a privacy perspective, do you think that we need a kind of a standalone regulation to regulate FRT, or it's actually just part of the personal data? So we can just use GDPR or broadly defined, that is kind of a biometric information. So we might have a standalone regulation for biometric information, not only for your facial feature, but also for your voice, the way that you move, for example. That is the first part. The second part, which actually confused me kind of a lot. So I know that the FRT has been used increasingly for different policy purposes. I know the book is mostly about the deployment of the technology in the public sector, but as you both say, so the majority of this use is still for law enforcement, but it's now kind of expanded to different purposes. Do you think that we need to have a different standard of scrutiny of these different purposes, not only for the law enforcement? So for example, for some general administration purposes like tax administration, so we can tolerate more of the use of FRT.
Rita, do you want to go ahead or shall I start?
You go. Now it's your turn.
Okay, thank you. Thank you, Jianli. These are great questions. I will first try to discuss a little bit the regulation of sensitive data, which is apparently the biometric data in the current laws, the GDPR and data protection laws around the world. So apparently, of course, we have biometric data sort of having more stringent regulations and the stricter rules under the data protection laws because it's the sensitive data. So on the one hand, apparently it's already sort of covered, and like you said, maybe we don't need any other regulation because we already have it covered. And on the other hand, I would say it's just slightly different in a sense that all data protection laws from around the world, there is not a single exception, are not in a way limiting. They are just setting again the procedures, the safeguards, how the data can be collected. But it doesn't say that certain data should not be collected at all. And I think that matters here when we talk about, for example, public space unlimited surveillance, because again, applying the kind of logic of data protection rules, and the sort of nature of those laws that is not really prohibitive as such, it's just sort of procedural. So we would then find ways to use facial recognition technology and other biometric technologies. You're right, there are many other biometric recognition technologies. One of the most interesting, I think, is the gait recognition, for example, how people can be identified through, the way that they walk. And apparently it's very different to the way that we all walk, and it changes with age and so on. So it's very easy to identify persons' sort of approximate age and other different aspects. So there are different possible ways to proceed, I think, in terms of how we regulate this. And I think that, but my bottom line is this: for certain users, and it perhaps touches upon your second question, which is, should we have different standard of scrutiny for different users and contexts of deployment? I think for certain users, we should completely ban it. And it is possible to actually ban the use of certain technologies. For example, let me give an example. We do not, at least to the best of my knowledge, in the majority of the countries around the world, approve and have banned human cloning. And so it is possible. It is simply not okay to do that. And like I said, at least officially, it is not in my knowledge that certain countries would permit that. So it is possible to ban certain things. And now this touches upon the second question, of course, law enforcement and other users and this level of scrutiny that is needed there. I agree. Perhaps if that was a suggestion or if it was a question, I think that, of course, different levels of scrutiny are needed. But one problem with very different levels of scrutiny is that, of course, it's possible for various state institutions to tap into the data banks or the systems. Let's say you mentioned tax administration, and let's say we have less stringent rules there than we have for the law enforcement. And then, of course, should the need arise, it's possible for law enforcement to actually access, welfare and tax administrative sort of data banks. So it is very problematic. And then in that case, it should have a very sort of strict rules how the data should not be accessed or should be accessed and so on. So maybe Rita can comment a little bit more on this, but I think that that was a very good point. And in fact, this was one of the reasons why we thought at least focusing on the state institutions sort of narrows our focus a little bit, because it's different issues, different rationales for adopting it. Of course, I'm still unaware of the very good reason, for example, to use facial recognition in the school canteen for, sort of school children. I do not find a good official reason, formal reason to justify that, except for, it's driven by the economic interests and development and collection of data of the private corporations, perhaps. It's very hard to justify that we need that for the safety, or security of the children, to see what kind of food they buy. Maybe their parents want to know if they're eating salad or they're eating French fries, but apparently it's not a strong enough reason. So I agree that, or perhaps I am of the opinion that, of course, different levels of scrutiny are needed, but we must be very careful in thinking how then this goes from that point, and data sharing or data access by other institutions, and the data collection or data use of the institutions for the purposes that were not really collected for those purposes. So I give the floor then to Rita.
Oh, sorry, can you hear me?
Yep.
Okay. So thanks, Monika. Yeah, I agree with most what you've said. To respond now, kind of to add to the first question that Johanna asked about kind of different approaches to regulating facial recognition technology, I should mention that actually in Australia also recently we had some former politician developing a draft kind of law for facial recognition technology. So it's like model law on facial recognition technology, kind of sui generis, so to say, legislation, and proposing that we need such a law. I think there are advantages and disadvantages, whichever approach you take. If you try to regulate facial recognition technology just under data protection privacy laws, well, here you mostly can deal only with privacy issues. But as we discussed, there are other issues, right? There are problems with, let's say, discrimination, both technical and like social bias kind of issues, and they extend kind of like to other human rights and freedom of speech, association, and so on, and transparency issues in a broader sense. To which extent you can incorporate all other aspects, all other issues in privacy bill, that might be, then becomes problematic from, kind of lawyers will say, oh, it doesn't fit here. But then if we start legislating a specific legislation just to facial recognition technology, then becomes for the question, then should we have laws on each different technology that comes in? Gait recognition adds on top, then emotion recognition, then, technology, then another on the top. And so does that mean we need special laws for each of them? Of course, nobody wants to have that many laws, and everyone will get lost. So that's the disadvantages of this approach. While at the same time, of course, advantage that you can incorporate, address all the variety of issues you see with these technologies, and not only, let's say, privacy. It is a choice that government should make. But my feeling is that the direction that at least Western countries are going is that they're trying, well, maybe I can't even say what's the direction, because European Union took this adopted EU AI Act, and that's where they regulated, facial recognition technologies, at least to some extent, in for law enforcement, and provided, general standards in this horizontal act. In other jurisdictions, I think it's more based still under privacy legislation. So I think countries are experimenting with different approaches, and and they might change as technology evolves. Now, briefly, in terms of the second question, I think, you asked whether different scrutiny standards to different facial recognition technology should be used. And I think certainly that's the answer is yes. I think we should, if we go back to that balancing exercise, I think we have to always see, like, if we're using facial recognition technology, how much privacy is affected in that particular situation. Let's say, kind of use of this technology in public squares to ensure security, and how much, what other public goal is being achieved, and is it being achieved? And then, kind of which one is sort of more important, and how we balance them. If you just use technology to check, what kids are buying in the school, what public interest is met here in comparison to the, to the extent privacy is interfered with. But on the other hand, I think that's another interesting thing is to, I think each country, people might have different feelings about their privacy. and kind of whether they really care that images are being taken and kind of saved somewhere. And like I remember I had to once wrote a short article about face smile and pay technology, which is apparently being used in China. I haven't encountered in Beijing, unfortunately, but it's people like apparently I heard they're using it, but I cannot imagine it would be ever accepted by a population in Germany, whether the privacy understanding is very different by people themselves, and then the balance is apparently, kind of already struck very differently.
That's great. Thank you very much. So we still have about 8 minutes left. I haven't received any questions from the audience yet. So if it's okay with you, I'm going to exercise my moderator privilege and ask a couple. So my first question actually kind of is a bit related to what Rita was just saying there. When we think about regulation of FRT, particularly in liberal democracies, I suppose, it's more likely to have a regulation if we think that the population is generally in favor, right? If the population has some sort of negative reaction to the deployment of these technologies. And I wondered if in your research or if other people in the book gave any consideration to sort of the voluntary development of FRT that people use in their day-to-day lives, right? So I'm thinking of how many people today unlock their phone using facial recognition technology and kind of small things like that. And I wonder if you think that kind of desensitizes people to kind of some of the privacy impacts the technology might have, or if you think that people separate out in their minds their own personal use of it and state use, whether they can separate those things out. The second question relates actually something specific to what Monika said in her presentation. You mentioned briefly about what you said, sort of the colonial aspects of FRT, and you had a slide with Africa on it. And it made me think, right? I think that the largest exporter of facial recognition technology, both hardware and software, to Africa are Chinese companies. And so do you see that as kind of some sort of neo-colonial project by China, or did you mean something else in terms of kind of this colonial aspect of FRT? So those are my two questions. Thank you.
Thank you so much. So I might start with this, Rita. Is that okay?
Sure.
Okay. Just a little update. I received a comment from a member of the audience that the city that I was talking about in China, where the police authorities identified a person in 7 minutes, is apparently called Guiyang, or others say that it's Xi'an. So I now will know. We'll have these two options to mention at least. So this is really useful. Thank you so much. I'm very grateful for that. Now, moving to the questions. First, about the sort of domestic, everyday today use of facial recognition technology, and perhaps a sort of a separation in our minds of the state use in sort of for public control and population desanitizing to these issues. So I would say that perhaps yes, for most of us and for majority of the people, it appears to be a separate thing. One thing that I use facial recognition technology on my phone. I don't really use that. I use the fingerprint, so it's similar. But that appears to be a completely personal sort of thing where, it's for convenience, and it's of course very questionable how the companies are, then using the kind of database that they have. And we know that they are using it for different purposes, that they are selling it or actually just giving it access to various institutions, related to law enforcement and so on. So we know it's problematic. We know it's related. We know it's used for various databases and so on. So perhaps we shouldn't be so naive to think that these are completely separate uses. But I think that at least from a sort of anecdotal evidence, I think that majority of the people do separate these things very strongly and might be very much concerned about the use of facial recognition technology in the public space, however, completely accept the use in sort of private space. Now, and of course, I think it's problematic, but maybe I'll leave this point to Rita because I still have to cover another point about the sort of colonial roots and also ongoing colonization with, and you mentioned the exportation of facial recognition technologies from China to Africa. Yes, definitely this kind of aspect is not only that we take a lot of resources from, by digging Africa for various various precious metals and other things that we need for the development of various technological tools and apparently powering the whole sort of AI system. So it's one aspect of that. So we do degrade and continue to exploit the African continent for these kind of things. Then in developing the technologies, we exploit a lot of labor, and Asia is, I think, particularly a spot where Western countries have been, relying on the cheaper labor in the Asian countries a lot for that. And then finally, developing the technologies and that are then being experimented with, let's say, in various countries in Africa. So the company that I mentioned that is a Lithuanian grant of the field, neurotechnology, for example, they work a lot with African countries in developing various things, in developing voting systems, in developing police, automated decision-making systems that are often secret projects and so on. But they do work a lot with various countries in Africa, also Asia, and so on. So it's a fascinating thing to follow that. But it is, of course, I would say, an ongoing sort of colonization project, because the data then that is collected, sort of, even if it's used by the law enforcement and other institutions, let's say in African countries, a lot of the data still sort of somehow is available for the companies that developed it in the first place and can be used for various experimental and developmental purposes. So I think it's a very big problem of power disbalance there. And I give the floor now to Rita, because I think we're running out of time. But thank you, Stuart, for this great question. Thank you.
Yeah, since we're running out of time, I will be very brief in responding to the first question by Stuart. So I think I agree with Monika that maybe people look, differently into private and state use of these technologies. On the other hand, I think that's the more we use them in personal space, the more we get used to that, and the more kind of opposition then we get against its gradual expansion. Right? If we kind of get to use that these technologies help us, makes our lives easier, then we see less problem with, whoever else is using it, as far as we don't feel any immediate harm. But the problem, I think, the problem, I think, is kind of that people often don't know about possible harm. And, that's why we have this book. That's why we have a discussion to just to identify to understand better that this technology is sometimes seems so seamless and so useful, but actually a lot of risks behind it. Before I started this project, I also have not given a thought about this facial recognition verification option on my mobile. But after I learned about all of these risks, about how our images can be even through our mobile taken, saved in databases, and sold and used for whatever facial other facial recognition trainment that can be used then by whatever police in whichever country, then I never choose an option to even kind of verify my face, verify my identity using my face on my mobile. So I hope overall this this discussion and this book will increase awareness of problems associated with technology and more careful use and more careful legislation to ensure that the balance of is reached, and we don't harm it. We're not harmed by it at the end, but really benefit mostly.
That's great. So much. Thank you so much. So yes, I think that brings us to the end of this. But let me again thank Monika and Rita for the excellent book, the excellent presentations. Thank you to Gian for organizing all of this and for your comments as well.